Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky.
So Judge, there was misunderstanding on this case. So on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is beer and a bag of candy. And so that's when I tried to contact him to get him to come in. Couldn't get in contact with him. Then he had to schedule a court date for the old cases, and that's when the court revoked his bond based on those old cases. He said he received the letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your newest case, because I don't know anything about it. Mr. Lestrade, you've now picked up a third theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Where is the trespass and the theft, the prior trespass and the prior theft? Can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens. Not once, but twice. What should I do now, Mr. Lestrade? What should I do? You tell me.
Judge, just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment, has some assistance from his mom, but obviously that's not a whole lot. That's the number.
That mom over there?
I'm not sure.
No, it's not. She at home.
Did you come with mom today?
No, sir. She at home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat. But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to over a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move.
Yes, sir.
Ray, I'm sorry. I'm not going to give another PR bond. You know, perhaps, I don't know, but you're not getting it.
Can we at least address the bond, though, Judge? Because I believe the bond's at
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today.
Yes, sir.
It goes with you. I'm with you though. 500.
Appreciate it.
We're setting the bonds ultimate.
I will. I really hope that you heard what I said to you earlier. Every time you go to this Walgreens, They know who you are, every single person. So every time you come back, what do you think they're going to do? They're going to watch you like a hawk, your every single move. You've been trespassed from there. So if you go back there and they call the cops, you're going to be right back in jail. Don't go back. You've worked out an agreement. They're offering you 60 days in jail with credit for the 2 days that you've done on this theft case here. Looks like they're going to dismiss the 2 other thefts that you have. You also need to understand this now makes at least 2 thefts for you. You pick up another theft, you're going to be looking at a felony charge, years instead of days.
Yeah.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. Are you sure you want to do this? Guess that's it, right?
Yes, Your Honor. I talked to him. He understands the nature of the consequences.
Okay.
Has no means of being able to afford bond, so we can look at the newer case. So he's opted to take the agreement on the old case.
If you can't ever make bond, if you don't have anyone in this life that's going to bond you out, then why pick up a criminal case? You know what I mean? When you leave here, Mr. Lestrap, come back. If you want a place to sleep, if you want a job, if you want food, I'll give it to you. All you got to do is come back. But if you keep picking up criminal cases, no more PR bonds. Do you understand? There's no excuse. We will give you resources. All you got to do is come back. You're giving up the right to, well, have I gone through the warnings? I don't remember. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there's no turning back. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty and I will sentence you to 60 days in jail. I will give you credit for the 2 days that you've done. It's not enhanced, right?
I think there's any.
Okay. All right. All right. Hi, good luck. Or did he say plead guilty?
Yes, sir.
I didn't hear it.
How do you plead to the offense, sir? Guilty or not guilty? All right. I'll find you guilty, sentence you to good luck. Thank you so much, Ray. All right. Good morning, Mr. Moore. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 31st, 2024, the officer initiated a traffic stop for the defendant's vehicle speeding 61 miles per hour in a 50 mile per hour zone at the 6100 block of South Highway 225. The officer made contact with the defendant, driver of the vehicle, and the officer observed an odor of marijuana. The defendant stated someone else possibly smoked marijuana inside the vehicle, and a PC search was conducted. The officer located 3 individual packages with a green leafy substance known to be marijuana based on training experience. The officer located these packages inside a red backpack on the back seat of the vehicle, and the marijuana was weighed, and the weight was 2.87 ounces.
Did you say, you said speeding? Did you?
61 and a 50.
Got it. Okay.
And Your Honor, if I may, there was an issue that I have with the PC. So in regards to the speeding allegation, there were 2 cars in front of my client prior to him being stopped. It was 3 a.m. in Pasadena. He had the nicer car and was pulled over. And also my client explained to officer when he asked him about the smell in the vehicle, he did tell him that he had CBD in the car. He said that I had 3 packs. I just purchased it. They're in my backpack in a bag. They were unopened at the time. The officer did take the bag so that he wasn't, he didn't know how CBD looked or smelled. So he was just gonna find it to be marijuana and would take him in for that, even though my client did prove up the fact that it was CBD in regards.
But if it's CBD and it's unopened, wouldn't smell, right? Because it's vacuum sealed.
Well, no, he said he smelled something in the car, but the substance that he found in the packages, they were unopened, and those were CBD. That's what he said that he found to be marijuana. But my client let him know that this is CBD. It's in my backpack. When you search, you're gonna find it. It's gonna be in there. But I purchased it earlier today from a smoke shop, and so when the officer did retrieve them out of the backpack and asked about it, he's like, "Well, I can't tell the difference between, what CBD and marijuana is. I only know marijuana, so I'm gonna have to take you in on that.
What form is this CBD in?
It was like in a little,
Is it,
it was a flower, so.
it is a flower.
Mhm. So I do know that the CBD flower and cannabis flower, they look very similar, so.
Your Honor, if I may, so as the DIMS establishes, so the odor was enough from the search, and finding that leafy substance is enough, because upon further testing, it may or may not, but just for the purpose of probable.
So I think for probable cause purposes, I think it's enough because the odor, right? Now, they're gonna test it. If it tests different, then there we may have an issue. But as far as probable cause, and your record speaks for itself, Mr. Moore. Anytime you get pulled over, what's gonna happen?
They gonna search me.
You know what I mean? This is what? 1, 2, 3, 4, 5, 6 marijuana case. Anytime you get pulled over with your record, what's gonna happen? Every single time. So why give them a reason? Really, we keep coming back and forth and back and forth and no. Can you run his license if he has?
Eligible, Your Honor.
All right, I'm not going to put any conditions. Just be careful. Don't pick up any new cases because I'm going to lose it at that point. You've got a great lawyer. Listen to her. She'll take care of you. If she tells me she can't get a hold of you, I'm going to revoke your bond. Just be good. Don't pick up any new cases. If you're going to drive, make sure you have insurance, car insurance. All right? Okay, guys.
Thank you.
Yes, ma'am. All right. Hi.
Yeah.
Was today his regular setting or was it a setting that we brought him in because he has bond violations?
This is regular setting.
Okay.
We had accepted the plea offer and we're ready to move forward today, before I got that email.
I have here that you have bond violation, Mr. Harrison, in that you were continuing to use alcohol. You are entering into a probation now, and I'm warning you that if you test positive again, I can amend your conditions and I will to put you into a rehab facility. And I can take you there kicking and screaming, and I don't care what is going on in your life. But if you continually show me that you cannot stop, then I'm going to do it my way. And I promise you, you're not going to like the way that I do it. It is a minimum of 9 months in treatment if you respond well. Do you understand? But it could be in an inpatient facility for up to 1.5 years of your life spent with me in jail. Do you understand? If I didn't get your attention enough last time, heed this warning now, because you will not get another one. You are charged with driving while intoxicated, second offense. They have agreed to reduce it to a first. And I hope that you thank them, because thereby you are now not going to do 5 days in jail, because that would be the mandatory minimum for you if you plead on a second. But I'm going to tell you now, I'm going to keep you on a very short leash. And one false move, they're going to file a motion to revoke. And if they prove it to me that you violated probation, get ready. For you to complete it, what are you pleading to is 180 days in jail to be probated for 15 months. As part of the conditions, you will do a repeat offender DWI education class. 2 victim impact panels. You must also do a TRAS. This TRAS is an evaluation to see what other conditions you may need. If they assess other conditions, which in my guess they're probably going to, you must fulfill those. It can be so much as intensive outpatient treatment, supportive outpatient treatment. Because you're continuing to drink while you're on bond for this case, it may very well say that you may need inpatient treatment. I don't know, but that's what you're agreeing to now. Do you understand? No drugs, no alcohol, random urinalysis. You must maintain a guardian interlock and a $100 one-time donation to MAD. One more thing that you must recognize here, that there is a requirement for a no breath test refusal. If you are driving in a car and you get pulled over, an officer asks you to submit to a breath test, you must submit to it. If you fail to, then they're going to take you to jail and you're in violation of this probation. Do you understand? You give up many rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. This is number 2. What happens the next time, Mr. Harrison? If I had one strand of hair, every time someone told me that it wasn't going to happen, I would have flowing, beautiful locks. You need to know what happens if you get pulled over again and you get charged with another DWI. What happens next time? You will be facing a 3rd-degree felony. You'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, if you even have a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk. You tell me now, well, it's not going to happen. You told me you weren't going to consume. Here we are. We've got you on a bond violation. Goes in here, goes out here. The only thing that matters are actions. Your words mean nothing. Actions speak louder than words, Mr. Harrison. How do you plead to the offense of driving while intoxicated, guilty or not guilty? I'm going to find you guilty. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out here in Orange. We're going to have a conversation as to whether you violated this probation. And if you did, you were looking at 180 days in jail. Do you understand? Okay. So the other thing that we have to do is the fines and fees for the DPS surcharge. It's a first. So it's a $3,000 fee, but let me ask you this. Is this a 0.15 or above?
Your Honor.
And is it alleged? Is it alleged on the information?
I believe it's alleged to be 0.15.
You should be walking out here with a $6,000 surcharge, but because they reduced it to a first, it's now a $3,000 surcharge. You must pay that in addition to the court cost. If you don't, for every $100 you owe, you will sit 1 day in jail. Do you understand? Okay. How do you plead to the offense? I will find you guilty. I'll send you to it. Good luck, son. Thank you, Ken. All right.
Judge, are you issuing a no driving license?
He has the portable device at this time.
Okay.
His license is suspended until February 18th.
Okay. Yeah, we need to do a no driving affidavit. You are not allowed to drive. I don't care what you're doing in your life. You'll be signing an affidavit with me today that you're not driving. I hope you're not driving at all. Take it seriously, Mr. Hunter, because if I catch you driving, get ready. Okay. So if he decides to, if he wants to drive, he needs the interlock before he even gets into a car driving. So we have to amend conditions to be able to do that. So he can't just start driving. You cannot just start driving. You are required to have an interlock in your car. There is a paper that we sent to DPS so that every officer in the state knows that if you drive, you're supposed to have an interlock. You get pulled over and you're driving and you don't have that interlock, they're going to take you to jail. Do you understand? Okay, talk to Kim. She can help you out when that time comes.
Thank you so much.
Thanks, Kim. So